A new study shared exclusively with CBS News is highlighting just how many anti-abortion laws are on the books in Louisiana. The study found lawmakers in that state have passed 89 restrictions on abortion since the 1973 Roe v. Wade decision.
That's the most anti-abortion laws to be passed by one state in the U.S. The report comes 1 month ahead of the historic Supreme Court case that may rid Louisiana of any abortion providers. So CBS News reporter Kate Smith is here to talk a little bit more about this report. So Louisiana, why does Louisiana have so many laws that are opposed to abortion rights?
So that's a really good question, and there are kind of two different answers depending on who you ask. But the first thing that's really important to know is that Louisiana has the lowest rates of support for legal abortion than any other state in the entire country.
Okay.
Only 30% of Louisiana residents believe that abortion should be legal in most or all cases. So that's kind of who these politicians are representing, which is so important to remember as laws get passed in the state. So depending on who you ask, they would say that either these are about patient safety, making sure that if a woman seeks an abortion, she does it in the safest way possible. Now, the other side of that camp would say that Louisiana just doesn't like abortion, right? All of these laws are aimed at shutting down abortion care, making it more difficult. And because of Roe v. Wade, they have to legalize it. They have to keep it legal. But that doesn't mean you can't try to at least try to regulate it out of existence.
So as you know, next month, Louisiana will be on the docket at the Supreme Court. Remind us of that case and how it impacts abortions in the state.
So this is a tremendously important abortion case for the Supreme Court. It's the first one that the High Court has heard since Kavanaugh's appointment. So really, people are really watching this. It's going to be very important in kind of how abortion, from a national landscape, how women access abortion. Now, the law at the center of it is something called admitting privileges. So it's the idea that an abortion doctor, or a doctor that provides abortion, I should say, has to have admitting privileges at a hospital within 30 miles of the clinic. Okay, here's the problem. In 2016, the Supreme Court saw a very, very similar Texas law. They struck that down. They said it was unconstitutional. It created an undue burden because of the effect of the law. In Texas, it shut down half of the abortion clinics in the entire state. Now, in Louisiana, as of course you know, this law would actually shut down all of the clinics in the state. So that's what they're going to be looking at in March. And what's important to remember, of course, about the Supreme Court is that if they uphold this law, then Texas can reenact their law that had been struck down 4 years ago now, and other states can also, get the green light to pass similar laws. So we're really not talking about just Louisiana here, even though that would be the immediate impact. It's really nationwide.
And often when we talk about these laws, we talk about the impact, the domino effect that could occur from state to state. But in regards to this report, how does this case give us some, does the report give us some more context as to why Louisiana is going forward with this specific case?
It does. So I was talking to the author of the report yesterday, and it's 89 different anti-abortion restrictions since 1973. Now, to put that in context, the state with the second highest is Indiana, with 63. So it's 50% more than the second state. It's really like in a league of its own when you're looking at just the sheer number of anti-abortion restrictions in the state. Now, what the author was telling me is that, so often, again, like I said, these politicians, they say that it's about patient safety. But if it's really about patient safety, it seems peculiar then that Louisiana would have had to have passed so many more anti-abortion restrictions than many other states. There are 5 states that have passed virtually zero anti-abortion restrictions since 1973.
And are they having many unsafe abortions?
I don't know the answer to that. I think there's an implication there. But 5 states, no, none at all. So to her, she was saying, when you look at the numbers, it kind of calls into question the intention of these laws. And I should also note that we reached out to the Louisiana Attorney General office this morning to kind of bring them that theory, see what their response is, and we have not heard back yet.
So let me just ask you briefly, what do the opponents of these laws plan to argue when it gets to the Supreme Court?
Well, their argument is very simple. This is settled law. We've looked at this in 2016. We found it was unconstitutional, and so we're going. So their argument is very simple. It's a legal one. It really isn't even about abortion for them. But if you do think it's about abortion, then like they found in 2016, this is unconstitutional. It creates an undue burden for women seeking abortion in the state. And that is a settled law. Planned Parenthood v. Casey, it's simply unconstitutional.
All right, we'll be watching.
Thank you.
Thanks, Kate, as always.
Thank you.